So I do, though, want to introduce you to our patron for this conference. He's right here, Jim Wolfe. If you just... So now we're going to start our panel on piracy. My colleague, Professor Robert Strassfeld, who is the Associate Director of the Cox Center and the Director of our Institute for Global Security Law and Policy, is the chairman. I turn it over to you, Bob. You need a microphone.
I'll borrow this for a second. Welcome. I guess we decided to recreate the Strait of Malacca right over here. Piracy is an ancient problem, one that international law began to deal with long ago. International law declares pirates to be enemies of mankind. They are not the romantic swashbucklers of the Johnny Depp movies. They are instead people in very fast boats with very scary weapons, including RPG launchers and AK-47s. It is also a multi-billion-dollar-a-year industry, and a growing industry, and one that presents challenges for international law. Our question today largely is, how well does international law continue to deal with the problem of piracy, and to the extent that it doesn't completely, what can be done? We have a terrific panel here today to address that question. And specifically, we have, I guess I'll start on my left, Associate Professor Milena Sterio of the Cleveland Marshall School of Law. There are extensive bios, which I will not repeat because I don't want to waste your time, and you can read them yourself. We've provided them to you for that reason. To my immediate left is Judge Rosemelle Mutoka. She is the Chief Magistrate and Admiralty Marshal of the Law Courts of Mombasa, Kenya. So she has immediate firsthand with piracy prosecutions. I will mention one thing that isn't in her bio. Not only is she here today, but she is also our distinguished jurist in residence this year, and we are delighted to have her as part of our new LLM program in international criminal law. Next is Sandra Hodgkinson, is it fair to say frequent visitor to this is hardly your first visit to the law school, who is Special Assistant to the Deputy Secretary of Defense. And to her immediate right is Jennifer Landsidle, who is an attorney advisor in the Office of Law Enforcement and Intelligence in the U.S. Department of State. With regard to our two panelists to my right, I will make the usual disclaimer for people who come here from the government, that they are speaking on their own behalf, not on behalf of either the Department of Defense or the Department of State. So we have a lot of ground to cover, and I want to make sure that there's time for your participation with questions and answers as well. So I want to start the discussion by asking Professor Sterio to tell us, what do we mean, or more specifically, what does the law mean when it talks about piracy? What is piracy?
Thanks. The definition of piracy under the main convention on piracy, which not just on piracy, but on maritime issues, which is the United Nations Convention on the Law of the Seas, Article 101 of that convention basically defines piracy as an act of violence committed for private ends on the high seas involving two vessels, the aggressor vessel and the victim vessel. And let me just clarify briefly why that definition is restrictive, and we'll hopefully come back to that throughout the discussion this morning. That definition is restrictive for various reasons. One, it requires that the act be committed on the high seas. Now, under the same convention, under the UN Convention on the Law of the Seas, the high seas are defined basically, can you not hear me? Sorry. The high seas are defined as the seas that stretch beyond the 12 nautical mile territorial sea, which is really within the sovereignty of the littoral state. So 12 nautical miles and then out is what we call the high seas. What that means for our purposes is that if the Somali pirates, for example, commit an act that otherwise really looks like piracy, but if that act is committed within the Somali territorial sea, that act actually doesn't qualify as piracy under this convention. So Bob mentioned, for example, the Malacca Straits. A lot of the acts that were, in the press called piracy in the Malacca Straits actually were not piracy under this convention because they were committed in the territorial waters of those littoral states. Now, why is that relevant? And again, we'll hopefully come back to this more. It is relevant because if the act is committed in, for example, the Somali territorial waters, if that act doesn't qualify as piracy under this convention, the question then is, even if you can capture the pirates, and the UN Security Council resolutions authorize patrolling states to go into the Somali territorial waters to chase pirates and capture them, even if you capture them, what do you prosecute them for? Because arguably you cannot prosecute them for piracy under this convention. The second reason why this definition is restrictive is because it requires the presence of two different vessels, the aggressor vessel and the victim vessel. Now, in the Somali piracy, the pirates, modus operandi there seems to basically almost always involve a pirate skiff, even a pirate, mothership, and then these smaller skiffs. So there we do have the presence of two vessels. However, there have been other instances where, criminals, hijackers, they hijack a ship, they board the ship in its last port where the ship is stationed, and then once the ship starts sailing, then they hijack the ship somewhere on the high seas. So that act, even though it is a violent act on the high seas, it certainly looks like piracy, would not qualify as piracy under the UN Convention. So again, in Somalia, we haven't really had that problem, but in some other instances, acts that look like piracy simply could not qualify as piracy under the convention. So some of you may remember in the 1980s, there was an incident involving the ship called the Achille Laura, where members of a faction of the PLO hijacked a ship sailing in the Mediterranean Sea. The hijackers had boarded the ship in its last port, and so once they hijacked it, because there was no aggressor vessel, just the victimless vessel, that act did not qualify as piracy under the UN Convention. Now, the third reason why this definition is restrictive is that it requires that the pirates act for private aims, for private ends. Again, the Somali pirates seem to be basically driven by financial gain. So they seem to be operating for private ends. However, to the extent that the act is linked to some political goal or some terrorist goal, there's an argument to be made that those kinds of acts, even though they again look like piracy, would not qualify as piracy under the UN Convention because they're committed for something other than private ends. Now, I should mention there's another, the UN Convention is widely accepted as representing customary international law, even though the United States is not a party to it. There's another convention that I will mention, which is called the Convention for the Suppression of Unlawful Acts of Violence Against the Safety of Maritime Navigation. That convention is basically referred to as the SUA Convention. The SUA Convention is not as widely accepted as representing customary law. The United States is a party. A lot of other states are parties, but for example, Somalia is not a party to it. The SUA Convention has a completely different approach to this issue of piracy. First of all, it does not mention the word piracy at all. Rather, it's listed on the UN website as an anti-terrorist convention, and it basically, in its Article 3, lists a series of offenses, a series of acts of maritime violence that are prohibited under the convention. So there, we don't have the same restrictive approach that exists under the United Nations Convention on the Law of the Seas, and there, acts that involve one ship would be covered, acts that are committed for terrorist or political aims also would be covered, and also acts that are committed in the territorial waters of littoral states would be covered under that convention. So I'll stop here and I will yield the floor to the other panelists.
Do any of you want to add?
Ashley's going to cover that one.
Okay. Well then, who can catch them, and what do we do with them once they're caught?
So when it comes to the capture of the pirates, under Article 105 of the United Nations Convention on the Law of the Seas, any state may capture pirates on the high seas. Why is that so? Well, because piracy really was the original universal jurisdiction crime. And in that sense, this panel really follows very nicely the previous panel where, the panelists talked about universal jurisdiction. So piracy is the original universal jurisdiction crime. On the high seas, any nation may go after pirates. So if there's an attack on the high seas, we don't have any issues with that. Any nation can go after the pirates. What was happening in Somalia was that the Somali pirates started launching attacks very close to the Somali territorial sea, and they would then quickly retreat into the Somali territorial waters, which again is that stretch of 12 nautical miles from the literal state shore, out 12 miles. And once they retreated into the Somali territorial waters, no other state could go after them because the territorial waters are really seen as the sovereign territory of that literal state. So to remedy that problem, the United Nations Security Council passed several different resolutions starting in 2008, and the gist of these resolutions was that the patrolling nations, the nations that routinely patrol the Gulf of Aden, now had authority pursuant to these resolutions to go into the Somali territorial waters to capture pirates. So as of now, any nation may capture the pirates on the high seas, and then these patrolling nations now have authority to enter the Somali territorial waters to go after the pirates. So the capture is, somewhat less problematic. What's more problematic is the idea of then the jurisdiction to prosecute pirates. Now, while the United Convention on the Law of the Seas gives any nation jurisdiction to capture pirates on the high seas, Article 105 of the convention says that the courts of the state which carried out the seizure may decide upon the penalties to be imposed. So a strict interpretation of this article is to say that basically only the courts of the capturing state may then prosecute pirates. Now, this strict interpretation, while it is supported by some scholars, has also been disputed by some other scholars who say that doesn't make any sense. This article doesn't really say no other states can be involved in the prosecution. It just says the courts of the state that carried out the seizure may impose the penalties. So there's sort of two disputed views, but the strict interpretation, the strict reading of this provision does say basically the courts of the capturing state should prosecute. That, of course, poses problems because a lot of the capturing states are really not interested in prosecuting the pirates, which is why a lot of the capturing states have turned to regional partners, like, for example, Kenya, to say, look, we'll capture the pirates, but then we're going to hand them to you for prosecution purposes. And I'm sure others have comments on this as well.
No, I was just going to chime in quickly. I think we'll get an opportunity to speak in a little while about some of the other regional efforts and some of the courts, et cetera, that have been established to address this and how we're working on it. But just to answer this question of who can catch them, a lot of operational work has been done following the line that Milena has very carefully laid out in the law. There's been a lot of tremendous progress, too, in joint and combined operations to try to carry out these actual acts of capturing. The United States has been a strong partner in anti-piracy operations off the coast of Africa through this combined Task Force 151 that was set up to try to help bring nations together to actually do some of the capturing, not just to stumble upon them, have standing ships happen to be there at the time when a pirate action occurs, but to more thoughtfully think ahead and try to work together as a concert of nations to try to interdict these would-be pirate ships and be in place close enough to the proximate attacks that were taking place. So there's the Combined Task Force 151. We've worked very closely with the European Union that has set up this Atalanta, which is a combined group through the EU that is working on counter-piracy. NATO has Operation Ocean Shield, OOS, which has been in place for several years now, and they've also continued to extend their mandate through 2012. So there is combined international effort to actually be there for this moment of the capturing, but then we will still get back to the questions and the challenges in the law and the questions of where to prosecute once either a victimized state, so the state that happened to have been pirated, whether it be the U.S., has a pirate come on board, and captures them that way, or whether it's a third-party state that comes in through one of these operations to assist another nation whose ship has been pirated. So there's a variety of ways in which someone can come into your custody, but at that time, then you have to look at the challenges to prosecuting them.
Could I just make a comment? Thank you. I wanted to make a couple comments on this debate, which I honestly did not know was a very serious debate about Article 105 in the Law of the Sea Convention. You know, the way that I would actually argue that a strict textual reading of Article 105, it's permissive. It uses the word may, that the capturing state may decide on the penalties, and that if it was supposed to be some sort of assignment of responsibility or jurisdiction only to the prosecuting state, it would say something like shall or should, and it does not. And clearly also as a matter of practice, what is going on in reality is that states have been historically, the prosecuting state, the capturing state certainly, they're the ones with the pirates in custody. They have to make a determination about what they're going to do with them, but there's no obligation on the prosecuting state that they must be the ones to prosecute. And in fact, as we'll describe in more detail later on, the practice has been, at least of the United States, to look to the states that have been most directly victimized by the attack, such as the flag state of the vessel that was attacked by the pirates. So again, without sort of, I'll get into that in more detail later, but I think it's important to recognize that Article 105 really hasn't been seen as a limiting principle on the customary national law tenet that piracy is one of the oldest and most well-recognized universal crimes.
Can I just ask a follow-up on that? In prosecutions where the pirates have been turned over either to the victim state or to a regional partner, has this question of the definition of Article 105 been raised, or is it purely an academic debate at this point?
I'm wondering if Judge Mutoka might be best placed to answer that. I am aware that it has come up. I believe it's been consistently held that recognize that piracy is a universal crime and that all states have jurisdiction. But I wonder if Your Honor.
Well, yeah. It has not in Kenya. It is not an issue. The Article 105 is not an issue. The issue actually related to which tier of the court would try piracy, but this particular one has not been an issue because piracy has been defined very clearly in our penal laws even before, and it was just amended so that it was made a universal offense. So it is not an issue in my country.
Let me just briefly follow up on something that Jennifer said. And I actually completely agree with Jennifer on this. You mentioned the sort of permissive approach of Article 105, and then the fact that the United States has looked at the states that have been most directly affected by the pirate attack and said, would you like to prosecute in a sense? That's really the approach of the SUA Convention, this other convention that I mentioned, which basically has a list of states which, shall prosecute and a list of states which may prosecute. So basically there's a list of states that have been the most directly affected by the offense, and those states, can prosecute. And then there's also a list of other states that are also allowed to prosecute under the SUA Convention. And the SUA Convention really basically gives a wide, sort of discretion. Most states can really prosecute piracy if they choose to.
Right. No, I think it follows really well on the last panel and this idea of universal jurisdiction, and certainly with piracy, nowhere in international law does it give you as a legal matter a priority list of who should be the first state to prosecute and on down. I think that there's an argument to be made that in the very same Law of the Sea Convention, it talks about the responsibilities of flag states for jurisdiction over acts committed on their vessels. I believe it's Article 94. So I think that's something that we've looked to in developing, as a matter of policy, which states will approach with a request for their interest in prosecution.
No. Bob, one last sort of limiting factor here to mention. Obviously, states that are bound by human rights treaties have an obligation under those human rights treaties not to deliver suspects to other states if there's a doubt that they will be mistreated in that third state. So obviously the United States, for example, when it looks to states where, it could potentially deliver pirates for prosecution, it looks to states that have a pretty, solid human rights record. But that would be a limiting factor if you, for example, wanted to deliver a pirate suspect to, I don't know, North Korea or, Syria or, a state that does not have a good, human rights record.
Well, I think we can appropriately now turn to what is the United States practice, and I'll let the two of you sort of sort out between you how you want to, who goes first.
Jennifer wanted to start with the U.S. policy and perspective.
Sure. So as I've kind of touched on, again, given that piracy is a crime of universal jurisdiction, when the United States developed our response, our very comprehensive response to the phenomenon of modern Somalian piracy, when we really saw the uptick in these attacks in 2008, we knew we had to deal with this question of when we captured suspected pirates, what were we going to do with them? And I think for us, the key here continues to be burden sharing. No one state can deal with piracy on its own. And so the international community really has to work together to address this issue. As I mentioned, when the U.S. government has captured suspected pirates, as a matter of policy, we have first looked at what states were most directly affected by that particular attack. Our assumption has been all along that those states would have the biggest interest in prosecuting the suspects who either attacked their vessels, or if there were nationals of their crew members on board, if they had cargo on board, the nationality of the owners of the vessels. In our view, we have just rescued that ship from a successful pirate attack, and so we've really gone to those states and said, hey, you're welcome, and here are the suspects that we've captured, and we've put together a great evidence package, and we'll be very willing to transfer them to you for prosecution in your courts. Unfortunately, I think the most disappointing thing we've seen over the past few years is a lack of receptiveness to those requests from states who we've approached. And we can get in more to more of the details about why that might be a little later on. But as a result of that, we have very thankfully been able to rely on our partners in the region, and these in particular have included Kenya and the Seychelles. A newcomer to this group potentially is Mauritius, who just signed a transfer agreement, and I can explain if people are interested the structure of these transfer agreements with the European Union and their naval forces just recently. So that's potentially a third country in the region that will now start prosecuting pirates who have been captured by international naval forces. It might be helpful to say a little about the transfer arrangements. Yeah. So, and each state has taken a slightly different approach to this, but at least with the United States early on, we decided that it didn't have to be a binding treaty, and it wasn't, but that it would be helpful to have a non-binding framework that sort of laid out the responsibilities of each side with respect to a transfer of suspected pirates from the United States to Kenya or to Seychelles. And I think it's been very helpful. We no longer, Kenya actually has terminated our MOU, it's a memorandum of understanding, since then, but it still is used in practice as sort of the framework of how is this going to work logistically. We've got captured suspects out there on the high seas. Our naval vessel very much needs to get back into action, so we're all about trying to reduce the amount of time that the suspects have to be on board the naval ship. So it's very helpful to have this framework that really lays out, okay, within a certain number of days, we make a request to you, we provide you with this type of evidence, which is what you're going to require in your courts. You have time to review it. You try and get back to us within a certain number of days. And then if you accept the case, and there's always in these cases, in our view, it can't be a binding commitment on a state until they review the evidence in the case, right? Whether their prosecutors are actually willing to accept the case and take it in their courts depends on whether they think they agree with us that it's a strong case. So they have that opportunity to review the case, and then we would transfer, if they accept, we would transfer the suspects along with any physical evidence and this evidence package that's been put together, which in our view, the United States evidence packages have been very strong and include witness testimony, witness statements, that sort of thing. So again, it's a non-binding framework, but we have had one with Kenya, and we currently have one with the Seychelles as well.
So I'll pick up a little bit from there on this sort of discussion of what's going on out there and what we're doing already. And just to point out that Kenya and the Seychelles have also benefited from the UNODC, which has developed a fund to try to help them strengthen their own capacity to do this. So, you know, one of the concerns early on was, would they have the expertise to try these highly sophisticated cases, particularly in the early days? And that's where international assistance was very helpful in coming forward with both funding and training to help get these courts a little more of the expertise they would need for successful prosecutions. But going back to Jennifer's point about nations not necessarily being willing in all cases to step into the breach and take these pirates for prosecution, a large number of pirates, even with the developing capacity, a large number of pirates are getting off the hook. I mean, there just hasn't been enough places for these prosecutions. Even where they were in the early days, Kenya faced some challenges I'm sure the judge will speak about with just capacity. I mean, there are so many of them, funneling them all into a few courts obviously makes there, you know, a problem and a challenge in trying to move them all forward while meting out local justice as well, your regular justice system, which has a series of crimes as well. So there has been lots of novel thinking, like with all great international law topics, not just here at Case Western, but of course under Professor Michael Sharp's lead, predominantly here at Case Western and Pilpig. But
This is why we keep inviting
yeah.
you back.
But there has been a lot of thinking of approaches and trying to adapt approaches that have worked in other contexts in dealing with international crime. So one we'll talk about right now is this so-called Jack Lang report. This is the report that came out through the United Nations Special Advisor, who was asked to look into options. Jennifer sort of laid out that we have the Kenya court, we had the Seychelles, Mauritius has started to work on prosecutions. We've had a good deal of successful prosecutions through these regional courts with, you know, strengthened capacity and financing from the international community. The United States, Germany, and the Netherlands on limited occasions, certain occasions, particularly where they've been victimized, have also taken jurisdiction over some pirate cases and had varying degrees of success in prosecutions. But the pirate attacks have continued. The numbers have grown. It's a tremendous financial burden on the region in Africa. I mean, a lot of the port states are getting more and more costs imposed on them, and it's harder to do business there. It's obviously imposes problems for all of us in international commerce and shipping. And so the Jack Lang look at this came out with another option, which is this idea of a specialized court. And his theory was that you could create a specialized court system, so a specialized piracy court, with two jurisdictions in Somalia, so in Somaliland and in Puntland, and that there would also be one outside of Somalia, in Tanzania was where he was proposing, but it could obviously be somewhere else, to extraterritorially, outside of Somalia, handle some of these cases as well. And his rationale behind it was looking to say, if we have a specialized court, we can develop the laws, train local judges, do it in Somali local languages. I mean, so it's the idea of a domestic court, but again, a specialized one that only focuses on this one particular crime. This court would require international funding on a voluntary basis and is approximately estimated at about $25 million a year for the course of 3 years, so about a $75 million bill, but that bill does not include the cost of any international lawyers or judges who would come down to help strengthen the capacity. And it doesn't include the cost of Somali judges either, although I don't expect their salaries would be commensurate at all with the international judges that would come. So to talk a little bit about this option, because it's a clever proposal. It tries to build on maybe the extraordinary chambers from Cambodia that has been a specialized court in Cambodia to address the former crimes in Cambodia. It draws a little bit on maybe the Iraqi High Tribunal, which is a more specialized war crimes tribunal in Iraq that was in Arabic to try Saddam Hussein and others. So it pulls from some of the varied war crimes models out there. But it's a little different in a few others, and we have some lessons from that as well. One of the points that I would at least make on this is that, when you have these specialized courts that are standalone courts, I think we've had a question as an international community as to whether or not we've had the full spillover effect into the local justice system that we maybe hoped for when they were first created. I mean, there's always been an argument that if you can bring a court to the host nation, then you'll strengthen their rule of law. And, I would argue at least that there's a developing trend that the more you mainstream that justice into the local court system, probably the better likelihood you'll have of that than having a standalone specialized court that may not be as transparent or accessible to everybody around. So this proposal, though, it is a specialized court, and there seems to be strong support from what you'll read from the Russian government, the French government, several governments in the United Nations for backing this. And the Somali government has given, we believe, strong support but mixed views to some degree. I mean, they've indicated they'd be supportive of a court within Somalia, from what you read in the press from their statements. Probably not outside of Somalia, so there's a question as to whether or not they'd support the extraterritorial aspect of it. But most recently, they failed to pass their own piracy law. So without a piracy law, you're going to have a very difficult time with a specialized piracy court. And so that's where the host nation's cooperation in this is going to be essential to making sure that this can actually move forward in a good way. One or two last points on this before we sort of turn back to the main discussion would be, there has been some other experience that I would just highlight from Africa, South Africa. Several other countries have done a really terrific job of taking their national courts and in crimes, particularly assault against women, domestic violence cases against women, of having specialized training of prosecutors and defense counsel, but within the mainstream courts. So it's the idea of not really a specialized court, but one chamber or one special courthouse in a region that develops some expertise in these particular cases, but isn't a standalone court, doesn't have a standalone court statute, isn't separately funded, but may benefit from additional training and support from the international community. And it has been relatively successful at trying to increase prosecutions for domestic violence. This might be a model that could fit with where Jack Lang is headed, which is trying to get this to be addressed in a way that international support can come in, but not necessarily require you to stand up a standalone court, separately fund it, try to come up with the expertise to come down, raise the money, and address piracy in a timely fashion, because some of our international tribunals have not been as timely as we would hope to have the deterrent factor that we probably need to get ahead of this. But I'll stop there and can comment more at a later date.
Well, a later date.
Well, later time, later, I don't want to keep talking while
But I
others.
do want to let
Yeah.
others, if they want to say something about.
Just very quickly, not so much on the Jack Lang report, but just on this issue of finding the right court to prosecute the pirates, and Jennifer and Sandy have already talked about this, but there's in the last year, I think it was last year, in the American Journal of International Law, Eugene Kantorovich, who's another piracy expert, he did this study of all the different piracy cases around the globe, in which he concluded that basically instances in which countries exercise true universal jurisdiction over pirates are very rare. So in most countries where pirates have been prosecuted, those countries have relied on other bases of jurisdiction. Why? Well, in most cases, pirates have targeted the ships of those states or have hijacked, kidnapped the nationals of those states. So true instances of universal jurisdiction over pirates are extremely rare. And just a short anecdote, there's also what I call the Russian approach. Some of you may have read about this. Last year, the Russians caught pirates on the high seas, probably thought about, what are we going to do with them? We don't really want to, bring them back to Russia for prosecution, but what are we going to do with them? They basically put them back on this little boat with no food, water, or navigational devices. And the Russian officials said, basically, we don't really know what happened to them. They probably died, but we don't really know. Obviously not the, preferred approach, but it really illustrates maybe the frustration that some of these, nations have felt when, trying to figure out what to do with pirates. And if we have a court where, that can handle pirate prosecutions in a large number, that could prevent this kind of an attitude.
As you pointed out, human rights conventions do apply
Yes.
to pirates as well. I want to follow up just a little bit on the Lang report, because Somalia is not Cambodia, and it's not even Iraq. And I'm curious about this conception that what you're creating is a Somali court. If Somalia could create its own courts, obviously these problems would be very different. I mean, to what extent is this a realistic model at all, do you think?
I mean, I'd make a couple comments on it. I mean, it's certainly a challenging model in Somalia. They have challenges overall with rule of law, but they have had successful pirate prosecutions. I mean, so they have actually moved some cases through their court system. And one of the challenges we've had in other tribunals has been this, desire. Most international practitioners who go to help support it want to be guaranteed that there's going to be these great international fair and free standards, but in order to get them to that basic point, they need the help first. And a lot of times the help hinges upon them being able to show just how good they are. So it becomes a little bit of a chicken and egg problem with funding and trying to get the support and the assistance to come in. But I think it's a challenge. I mean, it is a challenge in trying to develop that capacity in a timely enough fashion. I mean, we have done a lot of work in a lot of countries to strengthen justice systems where it just doesn't happen fast enough. But it does have, obviously, the golden dream that at the end of the day, you have a country that is far more advanced in rule of law than they were previously. So it meets other national goals we have. But one other limitation I would mention in addition to that is the fact that you really then just have a piracy deterrent for Somalia. And much like the drug trade and other enterprises, if we effectively meet out piracy in one part of the world, what's to say that it won't come up in another? And so this notion of more robustly strengthening national prosecutions around the world and the ability to do so, whether it's through SUA, through the development of customary international law, through getting good cases, and dealing with flag states who are affected and who are heavy into the shipping business, you may have something that is a more effective long-term counter-piracy strategy globally, rather than just addressing it in one corner of the world. And so the one advantage of looking again at these more domestic national prosecutions elsewhere and strengthening that as well, at least in concert with this, means that you'll have a more robust ability to deter it worldwide. Otherwise, some pirates, some would-be backers, may choose to go elsewhere, although probably not. A certain number of the pirates who are coming from Somalia are partly there because of the destabilized situation, but you may allow it to foster in other areas where there's similar destabilized areas, because Somalia is certainly not alone in its lack of stability and political stability. So there are some limitations to it, which you rightly point out.
May I just say something about that? I think going with the Jack Lang report, I still think that that proposal would make sense, considering the fact that, when you're talking about Somalia right now, you have little independent states calling themselves, a country. So there's Somaliland, and then there's Puntland, and I think there's a third one that I think just near the border with, between Kenya and Somalia. And so even if you have these little so-called countries within Somalia, and then you have all these other people who really do not come from those places, those are the ones that give problems, because they're the ones who you would not be able to govern. And so I still think that, and given the challenges that I've seen while handling piracy cases in Kenya, I still think that eventually, if we had something like a regional court that would not be based in Somalia, because like I said, it would be difficult to place it, I would still imagine, and if it is, if there's a lot of financial loss that is being incurred, then I think it is important that we have a regional court, because that perhaps would then, in the short term, address this serious problem, because I look at it as a very serious problem myself.
One 30-second addendum to the judge's excellent suggestion of a regional court. One of the challenges with Somalia in itself probably a security situation, which we've seen elsewhere. And because of the destabilized situation you have in Somalia and the great amount of gains and money that you can get from pirating, it's certainly not hard to imagine that specializing tribunals within Somaliland would require such a high level of security to have there be an incentive for prosecutions to go forward and to protect the judges and prosecutors who'd be working on those cases. Other specialized tribunals have certainly faced challenges of threats to judges and to prosecutions, both in Colombia on the drug side and Iraq on the war crime side. So that is another challenge to a court directly in Somalia.
Can I make a few?
Sure.
No, I was just very interested by everything that everyone just had to say, and I just wanted to throw out a couple other things for consideration when people think about, in what venue should we be prosecuting suspected pirates? Should they be going to national courts? Should we be thinking about some sort of international piracy tribunal, which I can tell you the international community has given a lot of thought to that idea. Should it be a regional court? Some of the considerations we've thought about have really been, first of all, that setting up some sort of extraordinary supranational judicial mechanism for piracy would be really unprecedented, given that piracy is a common crime. It's a very serious crime, but it's a common crime, and it's not one that has the types of characteristics that you typically set up an international criminal tribunal to deal with. It doesn't involve certainly government officials in Somalia. There are government officials that are complicit in acts of piracy, but they're not sort of out there. They're not standing in the way of the international community's ability to prosecute the suspects. In fact, we have them in our hands, and we're trying to find a venue and what to do with them. So I think that that's something we have to think about. If we do an international tribunal for piracy, why not for drug trafficking or murder or anything else? So that's one thought. I think another concept to keep in mind is this concept that really underpins the Rome Statute in the ICC, which is this idea of complementarity. I think if you're going to set up an international criminal tribunal, the idea has been that one purpose of that extraordinary mechanism should be to motivate states to take responsibility to prosecute these very serious crimes in their own courts. And I think what I worry about with respect to a piracy tribunal is that we're not seeing that motivation right now. I think that the states that have been most interested in setting up a piracy tribunal are not the ones who have taken responsibility and are prosecuting suspects in their national courts. They're the ones who want someone else to deal with this problem. And so they'd be very happy for the same group of like-minded states that funds every international criminal tribunal to set one up, pay for it, prosecute suspected pirates in that tribunal, and then they don't have to deal with this problem anymore. And I think that's concerning, certainly from a budgetary view, because this tribunal could go on forever and really just sort of feed on itself, and we wouldn't ever get to that winding down phase that you want to get to with International Criminal Tribunal. I think another thing, and Sandy pointed this out, but I think it can't be understated, the importance of if you're going to invest all of this money and expertise into a mechanism, shouldn't it be something that will have spillover benefits for the community and the general rule of law system in which it sits? And I think that's something that we've seen with the amount of money that has been invested in Kenya's judicial system and prison system, in Seychelles. UNODC is now rolling out an assistance program in Mauritius. And I think all of those are having, hopefully, spillover benefits for those countries as a whole. And that's definitely the intention and possibly a positive externality of what is otherwise a really the crisis of piracy. I also will comment that I think that we have to think about whether an international criminal tribunal might be, in fact, particularly ill-suited for a crime like piracy, where, again, the sheer number of suspects. And as complicated as the cases can be, because you're capturing suspects on the high seas and they need to be transferred to obviously a prosecution on land, though I have heard ideas of prosecuting suspects out at sea, and there's definitely logistical complications to these cases, but they're still pretty straightforward. I mean, if you catch a suspected pirate climbing up a ladder onto a boat, and you have all these naval witnesses, and you have the crew who was a witness to it, it's not the hardest case a prosecutor has ever had before him, I doubt. I mean, a prosecutor worth his salt. So, so I don't know if the cases are particularly complicated the way proving, command responsibility for genocide would be. So I think that's another, and definitely the pace of these, we, just to make sure that the prosecutions in the region have been numerous. I mean, around the world, we do have 20 states prosecuting pirates right now, and it's over 1,000 pirates are in custody all around the world in these 20 states. And I just can't imagine an international criminal tribunal with the capacity to turn out that sort of number in the 3 years that we've been dealing with this crisis. And a lot of these are very recent, actually. So we've seen a huge sort of uptick in the number of prosecutions most recently. Though I would agree with Milena that a lot of the times it is states who have a direct, they basically both captured the suspects and the suspects were attacking one of their vessels or nationals. So it's sort of a wholly Indian case or South Korean case or Japanese case, for example.
Well, just to underline that last point, given the number of catch and release instances, if there was a specialized international court, that number would be far greater probably, because there would be some place to dump them other than to send them back home.
Well, I mean, I do want to point out just one thing with the subject of catch and release. I think there's a little bit of a myth when you think when I hear numbers like 9 out of 10 suspected pirates who are captured are released without judicial consequences. A lot of those suspects, there wasn't enough evidence to pursue prosecution. So I think that the number that you really have to focus on is how many times are we releasing suspects because we couldn't find a willing venue to prosecute them versus all of the other reasons that a cop, on the street in New York sees somebody engaging in very suspicious behavior, but doesn't have grounds to arrest him and bring him down to the precinct. I mean, if you encounter some armed fishermen on the sea, in international waters off the coast of Somalia, you're gonna have to have enough to link them potentially to a specific attack in order to really have a solid case that someone's gonna wanna take. So I think we have to keep that in mind whenever we hear about catch and release. But
we have a lot still to cover, and I want to make sure that we have a chance to hear about the Kenyan experience and the use of a regional partner. So, Judge, if you could tell us something about that.
Okay, thank you. Now that we now know that they're not, it's not the Caribbeans of the pirates of the Caribbeans. Now we know that's a real problem. But the first time I went to Mombasa, and that was 2 years ago. Mombasa is a coastal town in Kenya, and that is where we do all the piracy trials. The first group that appeared before me, it was so unruly, a bit like what I see in the ICC International Court when some of those dictators appear there. And, I was surprised because these people were looking pathetic. They had not received medical attention. They were dirty. They had no representation, and they were very unruly and loud. And the first thing they said is, why are you presiding over this matter? Why are you allowing yourself to be used? Because I was new, so they thought perhaps they would have some leverage with me. But I was a bit concerned about how they looked like, and so I decided to engage the prisons authorities and also UNODC, who had come in also. And we talked about the fact that, we could not call that a trial if we did not ensure that we met some basic requirements. And the first thing we discussed and made sure we put in place was that they had representation. That was very basic. You find a group of 17, or they're usually more than 10. I don't think there's any case that at least that I've handled. And in Mombasa we had right now there are about 16 of them pending. You'll find that they are less than 10. But the most that they can do is get one defense counsel for all of them. That is what the United Nations Office on Drugs and Crime has been able to do so far. But it's better than what was there before. We managed to get them to go to hospital to address some of their very basic issues, like the ability to just, to get a place to pray and so on. And then we started seeing some sense of some order coming in. And like you've said, really, these are very basic trials. I mean, there's really no legal technicality involved as such. So the trials go pretty fast, but of course we have challenges in Kenya, many challenges related to facilities and so on, basically that. But if that is something that could be addressed, I think it would help. But these are challenges which I think if you consider that you're talking about the regional countries in the region, rather, agreeing to handle piracy cases, then the challenges become magnified. And then that's when you start seeing the reason why I think that perhaps if you have one court where perhaps you take these people to try them, then it would make a lot more sense. Kenya is the only country, I think, so far. I don't know about Seychelles. I know that maybe one or two cases where Seychelles is trying a case or two where perhaps they have interest. But I don't think any of the cases that we're handling that Kenya has been affected directly. So we just entered into this arrangement or agreement, the Kenya government with these other countries, international, countries that we were going to try, we're going to handle those cases. And it was going on very well with all those challenges that I've just talked about. If you want to get to know the details of that, then they're in my paper, which is in the bundle that was given to you, so I shan't talk about them individually. And, but then there was a problem. There was a problem, and then the government decided to withdraw the agreements that they had with these countries. So far, we are continuing with the ones that we have. They enter into agreements with countries on an individual basis. Just last year, this year, I think in May, we just took one case. No, just about, maybe about 2 months ago. We just took in a case just the other day. And so right now, it's not like they've stopped completely, but on an individual basis, Kenya will take some of the cases that are, that are brought to it. The issue of jurisdiction, I think there's been a misnomer about jurisdiction. There is a decision that was given by the High Court, and I think there was it came out as if the judge had said that Kenya did not have jurisdiction, but it was not talking about the country, actually. But it was rather, like I said, the tier of which court would handle piracy cases. But that is something that I think will be easily resolved now that we have a new constitution, which makes Kenya a monist country. So all international conventions that have been ratified by Kenya automatically become part of the law of Kenya. So this matter that has put a stop, or rather has halted the trials, some of the cases that were there, is going to be determined in October, or rather heard, and I believe by the end of October it should be determined, would then open up and ensure the cases are completed. But the reason why I would advocate a regional tribunal is because of the fact that it would be easy to handle some of the challenges that that most courts would encounter. And to me, I don't look at it from having had the experience of handling these cases. It is not, to me, it's not an issue of, because the issue of jurisdiction is something that once sorted out by the court, or rather, if once it is handled, then for me, a regional court would be the best court that would address all those little challenges that would ensure that the cases are heard and expedited at a much faster rate. So I would want to suggest, I would want to disagree with you to that extent, that maybe that would not be for the reasons that you've set out, that would not be a good idea. But my experience is that if we're going to handle and if we're going to tackle the problem of piracy, because the reason why it is very rampant right now where it is in the Gulf of Aden is because there's no government in Somalia. I mean, if there was a rule of law in that country, we wouldn't have that problem. It's not something that, it's a lucrative business. I mean, I say that because I know there are many Kenyans who would want to do it, but they know they can't, because they know they are going to be, definitely the law is going to catch up with them. But in Somalia, there's no government, there's no law. And if they could tackle the problem, of course, in Somalia, which is very difficult, we all know the reason, I mean, the problem that is there right now. That is the reason why I think that because it's a problem that's going to be there with us for some time, the best solution would be to do that. I remember when Seychelles took some time to agree to start trying piracy cases, and together with UNODC personnel, we went to Seychelles. And I remember when I was supposed to address them and tell them the reason why they should do that, because they had actually refused. They were looking for excuses. Every time a case was taken to them, even though they had agreed and entered into an agreement to take those cases, but they would always find one excuse or the other to send back the Somali pirates. So I remember when we were having a coffee, and one of the judges of the Supreme Court came and asked me, what is wrong with you in Kenya? Are you people idle? Why would you want to do piracy cases? Why don't you deal with the issue of corruption in your country, and rather than go doing something like this? And I was surprised, because this is a Supreme Court judge. But anyway, eventually when I addressed them and I talked about the fact that then it didn't look like a problem that affected the countries in the Eastern African region, because of course the ships don't, at that time, we were not directly affected, but I said it is something that was going to come to us. And of course it has, because right now we are feeling the brunt of the escalated costs that go with, with the ships having to go around so a long distance, and of course even the increased insurance cover. So at the end of the day, I think for me, given the experience that we have, and if we had a regional court, the ease with which we'd handle these cases, these are the kind of cases that would not even, if you started one, you wouldn't take more than a month to complete, and it would be expedited. I think if you look at the costs of setting up this court, I don't want to look at it from the perspective that you'd call it an international piracy tribunal or whatever it is. I don't know what construction you'd give it, but I would want to imagine that if you can have it centered somewhere, like, just have one source where you handle it. Eventually, anyway, we lawyers say that like cases must be treated alike. So if you capture pirates, and some of them are taken for trial, are brought for trial here in the US, and you take some of them to be tried in Kenya with all the challenges that we have, and you take some of them to, say, Tanzania, for example, then I don't know where the fairness of that is. And of course, obviously, they would all want to go to the developed countries. That is something they keep telling us all the time, because they know eventually, when they come out of prison, they're going to seek asylum. So I don't know whether that's what you want. Thank you.
Do you mind if I? So I just wanted to say how much I just enjoyed your comments, and I wonder if we can dig down a little bit more on the model of what this regional mechanism would be, because I think that there may be a way to thread the needle both between the advantages that you've just pointed out of having something that's more central, and so that there could be a focus for the international assistance that's being provided, so that there could be a focus for experts to come in and develop expertise in prosecuting or judging these cases, but still have it be essentially a domestic mechanism, something almost very similar to what Sandy mentioned, which is, so it operates, let's just use Seychelles as an example, since they've actually have put out a proposal like this at some point, that they may be willing to do this, which is the idea of sort of a specialized chamber within the domestic system of a state in the region that's applying their domestic law, but really is specialized on piracy cases. And hopefully they have existing domestic law on piracy that's very broad, and it incorporates the entire Article 101 definition. And then the judges that are there, hopefully maybe they could even have foreign personnel come in and be seconded in as prosecutors or judges. Seychelles actually has a very broad and rich tradition in this, and having other Commonwealth prosecutors and experts come and appear in their courts. So do you think that something like that might have some of the benefits without maybe having some of the positive negative effects that I was mentioning?
Certainly, I think that would work. Right now in Kenya, we have, it's called a piracy court, but it actually was built by, well, that was the intention, I think. But it's not used because there's a bit of a problem. There was a perception that was created by particularly the lawyers in Mombasa that this was like, we were setting up something similar to Guantanamo Bay. That we were setting up, we were having a courtroom in a prison facility, and then that restricted access, and we were going to have trials either in camera or in secret, and so there was a reluctance for us to use the court. So what we did is we decided to sell the fact that this was a court that would be used for all trials that were difficult, particularly those that would not be taken to the courthouse, and that it is something that is gaining currency in most jurisdictions where courthouses are now being built in prison facilities. And, and I think if we have, I don't know, because I still don't think the Kenya government has, shut out completely the arrangement that it had before. And I believe that if some pressure is brought to bear upon it, it can agree to have this facility used. It's a very, very good facility. It has potential, and it can be used for that purpose. And it can be expanded. It's just, maybe right now it's just one court, but I think it can be expanded because there's a lot of potential for doing so. Then you would bring it together, it would be easy. Perhaps then you would even use the domestic law in Kenya because it's already there. It's not an issue. The issue of jurisdiction is not there in Kenya. So if you can be able to do that, I don't know why they were talking about Tanzania when they tried to set up an extraterritorial court in Somalia, and then they sort of resisted, and I saw in the media and they said Tanzania had agreed, where Tanzania has not even agreed to do piracy cases yet. But I think it is something that can be pursued, and at the end of the day, it should be then easy to, to address, the concerns that you've raised.
So I was just going to quickly shift away from the sort of forum for prosecution and just raise a couple quick other points to consider, and I know at some point we'll have a few more questions and then I think open it up. But just a couple other considerations that you'll see out there in literature that you'll hear when you're reading are, one, there's been a concern about prison capacity in a number of places. So we focus on prosecutions, but there has to be a back-end place with humane treatment for these individuals to go. Particularly if the international community favors life imprisonment being the longest possible sentence rather than the death penalty. So you need prison space. You also need to look at this issue of higher-ups. Prosecuting every would-be, rankle pirate isn't necessarily going to be what deters the financiers who are making the most money. I mean, they're getting the biggest cut of this. They're backing it. They're weaponizing the individuals. They're helping a young, poor Somali, out of work, 23-year-old help do this, but they're backing it because there's tremendous gains. And so whatever forum you choose, there may really be a need to start focusing hard on going at the higher ups. And the UN has certainly pointed this out in their most recent resolution, but I think that has to be part of it. Also, the issue of freezing of assets. I mean, we've gained a lot of knowledge in working on this on terrorism cases. We need to apply this in piracy and make sure that the gains that are being sought are not actually being achieved. So one way to do that is obviously through trying to freeze assets of individuals who may be helping back or finance some of these operations, or freezing the assets and profits from it. Also trying to get at this issue of the ransom paying, because as long as ships and or states working together continue to pay these ransoms at $100 million a pop or whatever, you're going to end up making this lucrative enough. Yeah.
Four on average.
400 million bucks
no,
a pop.
No, four.
Oh. So, whatever it happens to be, it's a lot of money, and the ransom paying is a real problem. So this needs to be part of the overall package of solutions if you're really going to help deter this.
So we have made two promises to you, which it's going to be a little bit hard to keep them both. One, to provide sufficient time for your questions, and secondly, to address the theme of international law in crisis. So I want to invade just a little bit more of your time, but just a little bit more, to ask at the end of the line, and I think you've started that conversation, what, sort of what is to be done, to what extent, because the law of piracy is an old established law, well, some of it old and established, some of it more recent through the UN Convention. To what extent does it fall short, and what needs to be done, whether it's the law or the institutions? But I'm going to ask you to do this in a miraculously short amount of time, because I'm sure there are some questions people in the audience have as well. I don't know who wants to start.
So first of all, I do think that we have the laws, because we have the UN Convention, the SUA Convention, there are other anti-terrorist conventions, the hostage-taking conventions, so we have the laws, we have the treaties, it's just a matter of using them. In terms of sort of the way forward, what to do, I mean, I think we had a great discussion on all these possible models where to, prosecute the pirates. I think the bottom line is, one, rebuilding capacity in Somalia, which obviously is easier said than done, and then having a forum, whether it be some kind of a specialized chamber within a regional partner's already existing domestic criminal system, or whether it's some kind of a regional court. One additional point that I want to make about these prosecutions that hasn't been raised as much is, do we also, to the extent that UNODC, for example, is rolling the money to finance the prosecutions to help build the courts, do we also need to be concerned with adequate defense for the suspected pirates? Should we also be financing, should we provide them with, good lawyers? Should the international community be, concerned with this? Some people say no, why should we be developing a piracy, defense bar in Kenya or any other country? But I do think this is a serious concern, and to the extent that there are any kinds of allegations that the pirates are somehow not treated well, and what you said, for example, the first set of pirates that you encountered, how they looked so, so bad, I think that's a serious concern, and I think it undermines the legitimacy of any kind of a international prosecution.
Okay, what I'd say is this. The way you treat someone who has committed an offense is important. I mean, it's not just that you want to punish them, but you hope at some point that they're going to see the folly of their ways and reform. I think it is very important to look at all the proposals that we've made, and particularly treat these people with as human beings, because eventually one thing that I've seen with those that we've tried is that they actually say that most of them are illiterate, especially if you're talking about the foot soldiers that we are trying. We are not trying, I keep saying we don't try pirates. We are trying the foot soldiers, the people that are sent out there, the young men who are willing to do anything to make a quick buck because they don't even have any other livelihood. So, but when you reach a point where you engage with them and they tell you, look, I've realized that I didn't go to school. I don't know. I didn't know any better. And then they have alternative livelihoods. You give them, or you teach them something else to do. They turn out to be very different people. And I find them very, in fact, I keep saying that eventually they are even more respectful towards those of us who deal with them than the criminals, let me call them, or the Kenyans that we try, because the attitude changes completely, and it is very pleasing to me as a judicial officer to know that I can have an influence over somebody, and that they can turn around and they can say that I have learned from my mistake, and a lot of people don't do that, So it is very important that the treatment that you give these people is treatment that is basically that is given to everybody. And I think I agree with you entirely when you say that it's important that we must make sure that even as we try them, that we must make sure that some of these requirements are met.
I'll just quickly say, as I'm somewhat of an optimist, so I think we've made good progress. And so in that sense, it's not true international law in crisis. It's crisis evolving into something better. But I think we do need to focus on this national court jurisdiction and strengthening capacities in other countries to continue doing this. And if we don't focus on the higher ups and this ransom issue, then I'm just not sure we're going to ever get ahead of the curve. And, you know, we're gaining now, but unfortunately, I think that that's the big hurdle to overcome.
Yes, I will just reiterate some points that it's definitely not a lack of international law on piracy. We have plenty of international law. It's about implementation of that law by states parties to some of the conventions that Milena's gone through, criminalizing piracy under domestic law, and then using those statutes to prosecute these pirates. And then I just have to note also that I do think that the future of the international community's strategy with respect to piracy hopefully will address the ransom issue, though obviously the U.S. government has definitely the strongest views on no concessions for hostage taking, but is really about a retooled focus towards the organizers, the financiers, and facilitators of piracy operations. And that we could do an entire panel on sort of the specific international law issues that potentially come up that are a little bit different when you're prosecuting someone who likely is going to be captured on land. And, you know, can he be charged? Is he a pirate? I would argue yes. What other charge can he be prosecuted for? So that's a whole, an entire other discussion, but it's definitely, I think, the future of this issue. So.
Okay, we do have time for a few promised questions.
The issue that you raised and discussion that followed appropriately had to do on responses. And the judge mentioned about Somalia and being a failed state, because if you are thinking about prevention and not simply responding to it, then there is absolutely no other way to combat piracy but to see that on land there is a way to deal with them. The only instance where at the present time you can see Malaysia, Singapore, in that area, Indonesia, they tried, they succeeded, and a few years ago, all that you heard about piracy was in that strait, and it finally vanished practically. And then so at this stage, we can deal with all that ransom, and we can talk about the issue of courts, and regional court is a good idea, but I think we need to think about prevention, and in that sense, building capacity that the judge has said is the answer, but all these are simply at the present time symptoms that we are dealing with.
Arguably, the people with or the entities with the most skin in this game are the maritime insurers, the American Club, the London Club. What's their take on this?
They have, I mean, they've been lobbying, certainly in the United States. We've had a fairly strong effort of lobbying Congress to try to, you know, do more in this case. I mean, there's been efforts to put shipwriters on board. There's been efforts to look at ways to, there's even been requests to use the U.S. military or U.S. government forces to go on board ships to try to help prevent them from being pirated, which we clearly wouldn't have the capacity to do. So there certainly is an interest, and they are interested parties who probably can help ultimately in crafting some of the solutions.
Yeah, I mean, the maritime industry generally has been a partner, really, in our counter-piracy response. So one of the most effective things that's been done is shippers taking on self-protection measures, basically promulgating best practices with respect to pirates, and small things you can do. You know, go a little bit faster, have a little bit higher freeboard, have maybe a water cannon or all these other things that Sandy probably knows better than me on board that helps you evade a successful attack, and that's been very successful. The maritime industry also has participated in a lot of the international meetings that we have on piracy. I would be remiss if I let this session close without mentioning that the contact group on piracy off the coast of Somalia has really been the primary international forum for discussions of piracy issues, and is actually itself a great example of sort of non-formal international coordination and communication among states, and may ultimately serve as a model for a response on other similar issues.
What about the insurance companies, though, the clubs? I mean, if they were to stop writing policies that provide ransom, there wouldn't be any ransom.
Or stop, I mean, the ransoms are paid from insurance policies.
Right.
So, I mean, that's a...
And they write the policies.
Right.
They can
Oh, no.
put an exclusion in there.
We would welcome the opportunity to work more closely with maritime insurance companies about an incentive structure that would de-incentivize the payment of ransoms, and again, I mean, I think and also encourage these best practices that I mentioned. So.
Because you only have about 3 or 4 entities to deal with. The American Club, the London Club, the Singapore Club, and there may be another one.
Sounds like you know them. Maybe we'll
Can I ask the time masters, is there time for 2 last questions?
Just 10 seconds. I know I yield to Dean Scharf here, or Associate Dean Scharf, whatever. But I just wanted to know, we did an ABA standing committee, CICE, piracy roundtable in Washington with all the ship owners and the insurers, and they all want to be able to, alas, they all are committed to being able to pay ransom. So you're going to have a lot of persuasion to do in the industry. I'm sorry, Michael.
No, that's all right. I do want to end on time because, especially for human rights purposes, it's lunchtime. So first, Bob, why don't you close, and then I'll give some announcements about lunch. Go ahead.
Actually, I don't want to take any additional time other than to thank the panelists.